Excuse me, everybody. Please continue your meal. Make sure you have the dessert if you haven't had it yet. And please continue with your coffee and everything else while we start the program here. Before I introduce my guest, I want to say thank you I see some board members here in the audience. Jennifer Hughes, Cliff Buddle, Ken Ming Liu. Thank you for coming, board members, and also other distinguished guests here. The elements are on our side. We're only at T3. I am told that they decided to hold off on the T8 until after this event, so we're all going to be good. You'll be able to get back to Discovery Bay or wherever else you're heading afterwards here. But 4 o'clock after that, all bets are off. But the gods decided to hold off because they knew this was such an important and sold-out event. And for our speaker here. As we know, Article 23 says that the territory was supposed to act its own national security law. That attempt failed in 2003 after widespread public opposition, but now we are hearing that it's going to happen probably sooner rather than later under the revamped LegCo. And our speaker will talk about security law in Hong Kong. Is the law needed? Maybe give us some hints as to what he thinks may or may not be included in there and how the security law has changed Hong Kong. Cheng Huan has worked as a journalist before becoming a lawyer, and I must say he's been a long-time member of the FCC and uses the club regularly. He worked for the Far Eastern Economic Review, Asia Week, and The Guardian, and he first got called to the Hong Kong bar in 1986. 1986 is strong in my memory because that was also when I first went overseas as a foreign correspondent for the Washington Post. He was born in Malaysia, educated in Singapore and the UK, had a degree in law and a diploma in international law at Cambridge University. He writes a regular Sunday column for Tsingtao, and his latest book, Reflections, Childhood, Student Days, Law, and Other Writings, is available just over here, and I believe he'll be available to sign some copies. If you're willing to pick up a copy of that. And I do remind you that the holidays are coming up and books make great Christmas gifts. So without further ado, Cheng Huan.
Thank you very much, Keith, and members of the board for inviting me, distinguished guests. Your invitation to speak today came as a most agreeable surprise, as did the news that it has attracted a full house. I don't know why, but I'm told that all the seats were sold within hours, and the last time that happened was when Chris Patten was the speaker, which perhaps goes to prove, I suppose, that the FCC delights in all shades of opinion. When I told friends that I'd been asked to speak about the national security law at the FCC, many reacted with words like, "What? They'll give you a rough time," and one even say, "You are mad. They'll eat you for lunch." Well, here I am. I just eaten lunch, and I'm still alive. Eons ago, I myself was a humble journalist, so I know what a splendidly friendly bunch of people journalists are. After all, the FCC is a broad church practicing open democracy and tolerant of all shades of opinion. It preaches what it believes, freedom of speech, and even the freedom to hold different opinions. So I trust you will listen to the evidence with impartiality and with disinterest, consider the law, and reach a judgment without fear or favor, in the legendary traditions of not only that hello bar downstairs, but also the other bar, the one with a special B, of which I'm also a proud member. I'm much tempted to grasp this opportunity to promote my new book, but you'll be glad to know the constraint of time prohibits me from doing so. So here I go, the national security law, a new era, and the end of turmoil. It's a big subject. I don't have much time, so I'll get on with it. Before anything else, perhaps I should say that I'm here solely as a lawyer. I know that there's been political resistance, even outright hostility to the national security law, but that's a matter for journalists, politicians, and commentators. It's not for me. My interest is the law as it was, as it could have been, as is now and as it will be in the future. Perhaps first a bit of background. Obviously, all sovereign states have laws to protect themselves and to maintain internal security. But there is no universal concept of national security, and each jurisdiction strikes its own unique balance between security and freedom. The severity of security laws ranges wide from one jurisdiction to another, but laymen are often surprised to discover how onerous and oppressive they can be, even when created by liberal Western democracies. Britain, for example, enacted extremely rigorous internal security laws in all its colonies, laws which most colonies found it expedient to retain when they became independent countries. Malaysia is a good example. The government in Kuala Lumpur has made frequent use of the Internal Security Act, inherited from British rule. In 2012, it extended the old colonial law, making its security law even more onerous with the Securities Offences Special Measures Act. The same applies to Singapore, the law that allows persons to be detained without trial for lengthy periods. In fact, a few days ago, on the 4th of October, Singapore added an extra law to tighten the control of foreign interference in Singapore affairs with the Foreign Interference Countermeasures Act. With a low burden of proof, Singapore's Minister for Home Affairs now only has to suspect that online communications are occurring on behalf of a foreign party and believed that it's in the public interest for him to issue orders under the law. Thailand has similar laws. Even in the United Kingdom, extremely harsh security laws have been used, most notably in Northern Ireland, during the 30 years of civil disorder there, known as the Troubles. After the 1911 acts of terrorism, the United States widened its security laws, affording them global reach and jurisdiction. Terrorist suspects arrested anywhere in the world, and some were even taken to the United States military base in Cuba for further interrogation and long-term incarceration. The extreme technique of waterboarding was routinely used to extract information, almost certainly in contravention of universal conventions against the use of torture. Now let's look at Hong Kong. I shall briefly survey how public order was regulated in colonial Hong Kong from the 1966 Public Order Ordinance up to 1997, and then proceed to the 2014 so-called umbrella movement and the 2019 riots, and finally the national security law. Before the 1966-67 riots, public order and security were upheld by essentially three pieces of legislation: the Societies Ordinance, the Peace Preservation Ordinance, and the Summary Offences Ordinance, and of course the common law. The 1966-67 riots were so violent, British troops had to be deployed. So great was the disorder that the colonial government strengthened its powers, enacting the Public Order Ordinance, which widened existing laws to control organizations, unlawful assemblies, and riots. Some FCC members may well recall the existence at that time of the Semi-Political Reform Club, which was founded by a very distinguished member of the bar, Mr. Brooke Bernanke. His Reform Club famously launched an attack on the proposed Public Order Bill, claiming that it would, quote, catch small fishes in its net and big fish could escape through gaping holes, unquote. Yes, even in those distant colonial days, there was senior counsel who disagreed with the executive. With the benefit of hindsight, I must say I agree with Mr. Bernanke. The Public Order Ordinance did focus on the prevention and control of disorder, but did little to target the real culprits, the ringleaders who orchestrated the disorders and the subversion against authority. Security legislation always attracts criticism, and the 2020 National Security Law is certainly no exception. Article 23, when enacted, will no doubt get its fair share too. And then I'll now move on to the 5 years from 1997 to 2002. The early years after 1997 are fondly remembered as the years of so-called maximum autonomy for the SAR. I prefer to call them the honeymoon years. As you know, the honeymoon ended suddenly and brutally because of Article 23 and the political controversy it fomented. The chief executive, remember, Mr. Tung Chee-hwa, and his administration were required by the basic law to introduce Article 23. After a 3-month consultation period, they did their legal duty in February 2003 and dispatched the National Security Legislative Provisions Bill to LegCo for debate. The bill concerns acts of treason, secession, sedition, subversion, and the protection of state secrets, and became a very hot political potato, with the British American governments expressing the opposition and encouraging the people of Hong Kong to oppose the bill. The result was a massive protest rally of 500,000 people on 1st of July 2003. Let's pause for a moment and ask, what if question? What if the 2003 bill had been enacted? Would the 2020 national security law have been necessary? If so, would it have been as onerous as it turned out to be? In retrospect, in the excited popular opposition 2003 bill, did those 500,000 marchers do themselves and Hong Kong as a whole a disservice in the long run? Personally, even in 2003, I always felt Hong Kong had done itself a disservice. The SAR was left with the burden of an unfulfilled constitutional duty. Secondly, other jurisdictions around the world had security law, often much more vigorous. So why should Hong Kong think itself not entitled to have one? Thirdly, the legislative intent of the 2003 Article 23 was to ensure that Hong Kong should never become a base for subversion against the mainland. Surely an intent everyone agreed with. And lastly, surely every right-minded citizen understood that the correct understanding of one country, two systems meant that two systems could never outrank one country. The Article 23 controversy, as subsequent events proved, marked a watershed in the constitutional relationship between the mainland and Hong Kong. After Tung Chee-hwa's administration, there was no further attempts to introduce Article 23 in Hong Kong until now. As law professor Albert Chen has wisely warned and said, the constitutional duty cannot be abdicated indefinitely. Article 23 continues to be the cornerstone or the litmus test as to whether two systems can protect one country. The widely held view of constitutional lawyers has been that because of the 2003 watershed, the central government shifted its ground and moved away from a policy that gave more weight to two systems instead towards a revised policy where more weight was given to one country. Let me move on to the so-called Occupied Central Movement and the so-called Umbrella Revolution. The date was June 2014, and the first white paper regarding one country, two systems was released in Beijing. The white paper stated that under the Hong Kong SAR system, the central government exercises overall jurisdiction over the Hong Kong SAR, and yet the jurisdiction includes the powers directly exercised by central government. In the words of the white paper, the Hong Kong people who govern Hong Kong should above all be patriotic. With those few words, the central government actually drew a line. This set a sort of minimum standard which Hong Kong politicians and members of three branches of the government must adhere to: be patriotic. Soon after the white paper, in a decision on August 31st, 2014, concerning electoral framework for LegCo in 2016, and for chief executive in 2017, the NPC further laid out the details regarding the key principles and procedures for universal suffrage. The upshot of all that was a 79-day-long umbrella revolution. Not until 15th of December 2014 did the so-called revolution fizzle out, and the last remaining occupied zones were cleared in Causeway Bay and around the LegCo complex. hundreds of protesters arrested under the Public Order Ordinance. The havoc caused by the umbrella movement had massive social and economic repercussions that affected the entire population and led to severe and socio-economic damage. The Occupy Central movement bred extremism with the demands for localism and even independence. In the wake of these events came the extradition bill crisis and then the national security law imposed from above. It is worth looking again at the spark that ignited the latest fire. The spark, we remember, was the Poon Hin Wing murder case. A Hong Kong resident named Cheng Huan had confessed that he had brutally murdered his pregnant girlfriend in Taiwan, in Taipei. The Hong Kong government was unable to charge him with murder because the offense had been committed outside the jurisdiction. To remedy an unfortunate situation, the government took the opportunity to formulate a radical shift of extradition regimes by proposing a combined legislative amendment to two ordinances relating to fugitive offenders and mutual legal assistance. This widened the scope of the current extradition system and sparked the biggest political and constitutional controversy in the history of Hong Kong. To deal with the legal loophole, in February 2019, Hong Kong Security Bureau proposed a bill to amend the Fugitive Offenders Ordinance. The proposed amendments would have allowed the government to extradite fugitive offenders to countries of origin without extradition agreement with Hong Kong, including Taiwan, Macau, and mainland China. The Hong Kong Bar Association released successive position papers on these matters on March the 4th, April the 2nd, June the 6th, and June the 21st, 2019. They argued the amendments would fundamentally imperil the operational rule of law in Hong Kong. From March 2019 onwards, thousands of protesters participated in a series of massive and destructive riots that lasted for several months and which continued even after the chief executive had withdrawn the amendment bill. It was as if the writers smelled blood. As was to be expected, various international organizations, foreign bodies, in collusion with people in Hong Kong, started to intervene themselves into Hong Kong's affairs. For example, the European Parliament passed a resolution on July 18, 2019, regarding the situation in Hong Kong, calling on the government to withdraw the bill. In November 2019, the United States Congress passed the Hong Kong Human Rights and Democracy Act. For nearly 17 years, Hong Kong had been torn apart by division and the prospect of Western-style democracy, which is worth remembering had been initially promised and promoted by the last governor against the advice of statesmen like Lee Kuan Yew, businessmen like Willie Purvis of Hong Kong Shanghai Bank, and even senior British foreign officials such as Percy Craddock and his fellow Mandarin-speaking Mandarins. So it was then, on the background of this particular matter, it was then in June 2020 that the NPC Standing Committee passed the Hong Kong National Security Law. The legislation was therefore listed by way of Annex 3 to the Basic Law and immediately gazetted. Coincidentally, 23 years after transfer of sovereignty, at the stroke, the National Security Law ended the extradition bill crisis. A new legal order emerged. A legal order continues to evolve. The job is not finished. There's work to be done, holes to be filled, loose ends to tie up. Now, the principal purpose of the new national security law is to deal with 4 criminal offenses: secession, which is a declaration of independence from the ruling government; subversion, the attempt to overthrow the government; terrorist activities, the intimidation of persons through the use of force and violence in order to achieve a certain goal or end, and collusion with foreign forces. All these offenses are now punishable with a minimum sentence of 3 years up to a maximum sentence of life imprisonment. Now, it's time to make comparisons. To compare the 2020 National Security Law with the defunct 2003 National Security Bill. In other words, to compare what we have and what we could have had. As I explained, the national security law the present new national security law is much more burdensome, more sweeping in its powers than the 2003 counterpart bill. That's because in 2003, the Hong Kong government incorporated numerous concessions to meet demands by civil liberties groups. What are the differences between the then proposed National Security Bill of 2003 and the National Security Law of 2020? I have time only to give 3 examples. First of all, normally, but with a number of exceptions under present law, the police must have a court warrant to carry out searches of premises, etc. In the original 2003 bill, it was envisaged that the police had the power to carry out searches without a court warrant, but only during emergency investigation. That's proviso. Only during emergency investigation. Later, this power was removed. It was a considerable concession by Dong Chi-Hua, a concession sadly lost forever, because under Article 43 of the present law, there is no reference to any court warrant to carry out searches. So there's a fundamental difference there. However, the Hong Kong government modified the rules by stipulating that the police still has such a power to carry such searches with a warrant, but only under exceptional circumstances. So there's certain legal variation. No doubt there'll be tests to determine the legal definition of the words under exceptional circumstances. Now, it's worth noting that the practice of police searches without warrant is very common in many jurisdictions. In the United States, for example, the Patriot Act permitted the federal government to use a whole range of search and surveillance tools to support the Bush administration's so-called war on terror. The Patriot Act even allows investigators to conduct electronic surveillance on an unlimited range of terrorism-related activities and permits law enforcement officers to conduct sneak and peek searches, which can be backed by delay notices of judicially approved search warrant. So the judicial approval is obtained after the event rather than in advance. So the logic goes to avoid tipping off the investigated parties. This is a highly ingenious legal solution. The second difference concerns an essential ingredient in secession and subversion cases. Secession and subversion are offenses that are now punishable by maximum life imprisonment. Now, in the 2003 bill, secession and subversion would only be classified as criminal offenses if one of the essential ingredients could be proved, that is, using force or serious criminal means. Using force or serious criminal means. Under the new national security law, Article 20 and 22, the tests are now less stringent. The prosecution need only establish acts whether by force or threat of force. Again, the legal terms, but it shows the differences between 2003 and 2020. Now, finally, we come to the third and substantial difference between 2003 and 2020. In 2003, the bill mainly regulated Chinese nationals, whereas under the 2020 law, the law is boundless in the sense that there's no restriction by way of either nationality or the location when the offense is committed. 17 years ago, when Hong Kong officials looked at the possible scope of security offenses, they proposed to limit crimes of subversion and secession to permanent residents of Hong Kong only. They also narrowed the application of new offense of treason to Chinese nationals, regardless of where the crime was committed. According to 2003 public consultation document, these amendments to the proposed 2003 bill were the result of intense lobbying by foreign, mainly Western government international companies, which employed large number of foreign nationals in Hong Kong. Now, the difference between Article 38 of the new national security law is very significant indeed. The law now states that it covers anyone in Hong Kong, regardless of nationality or residential status, and also applies to offenses committed, I quote, from outside the region by a person who is not a permanent resident. This suggests that foreigners may also be prosecuted upon entering Hong Kong and mainland China. So there's a fundamental difference between what we could have in 2003 and now this very strict and onerous law. On the other hand, it has to be noted that quite a few countries, including the United States and Australia, have established a similar extraterritorial jurisdiction over acts of terrorism, while Britain also has passed the Counter-Terrorism and Border Security Act, which extends territorial jurisdiction over some terrorist offenses. And Germany, of course, under the Germany Criminal Code, Section 5, also comparable clauses governing offenses committed abroad. Now, the next, and I believe and hope the last element of this unfolding security legislation will be next year's Article 23. As mentioned, the current national security laws outlaws, first, acts of secession, 2, subversion, 3, terrorism, 4, collusion with foreign forces. However, it does not cover all offenses spelled out in Article 23. Offenses yet to be addressed include treason, sedition, theft of state secrets, a ban on foreign political organizations or bodies from conducting political affairs in the cities, such as espionage, and local political bodies from establishing ties with the foreign counterpart. While Hong Kong Crimes Ordinance covers some aspects of national security, such as treason, it has not been updated to reflect the change of sovereignty. As the Secretary for Security, Mr. Tang has also suggested, the new law may also involve a ban on targeting hatred and contempt for the Hong Kong government. Obviously, the zigzag can only be completed after Article 23 is legislated. This myriad of security law has opened a new chapter in Hong Kong legal history. But Article 7 of the National Security Law is very clear. It states, the Hong Kong Special Administrative Region shall complete as early as possible legislation for safeguarding national security as stipulated in the basic law of the Hong Kong Special Administrative Region and shall refine relevant laws. So even under the new national security law, we are legally bound to enact Article 23. It is worth remembering that Hong Kong Basic Law remains committed to democratic development. Article 45 of the Basic Law states that the ultimate aim is the selection of a chief executive by universal suffrage. And Article 68 states that the ultimate aim is the election of all members of the Legislative Council by universal suffrage. In my opinion, in 2019, Hong Kong has reached a fateful critical point. The security situation had become potentially calamitous. The vandalizing of Legico, the bomb making, the demands for independence, the blazing destruction of public and private property, the interference of foreign forces and so on, finally broke the mainland's patience. A patience that stretched back 23 years or 17 years if 2003 is the starting point. To restore law and order, a national security law had to be imposed on Hong Kong SAR. The alternative would have taken Hong Kong down a dead-end road of increasing turmoil, and most probably the application of Article 18 of the Basic Law. The use of Article 18 would have suspended and abolished, and perhaps abolished one country, two systems, and extended Hong Kong law, mainland law, to the Hong Kong jurisdiction. As a warning of what might have been Hong Kong's fate, it's worth quoting the last paragraph of Article 18 under the Basic Law. It says that in the event that the Standing Committee or the National People's Congress decides to declare a state of war or by treason of turmoil within the Hong Kong Special Administrative Region, which endangers national unity or security and is beyond the control of the Hong Kong region, beyond the control of government of Hong Kong, decides that the region is a state emergency, the Central People's Government may issue an order applying the relevant national laws in the region. So one stroke, Chinese law could apply, could be implemented in Hong Kong in a stroke if, in fact, Article 18 is implemented. If I may end on this note, my biggest grumble, disappointment, regret, call it what you will, is that for 17 years after 2003, one administration after another, and especially the members of LegCo, consistently failed to carry out the constitutional duty according to basic law by not enacting Article 23. Because they failed to do so, Hong Kong now has a national security law imposed from above. This should never have been necessary. There was next to no input by Hong Kong as to how the 2020 law was to be enacted. The law's contents, that is the 2020 new national security law, did not pass through the legislative scrutiny that all local legislation must go through. I very much hope this mistake will never be repeated, and I hope Hong Kong can enact Article 23 as soon as possible to complete the legal jigsaw. If Hong Kong is again negligent of its duty, we should not be surprised if the central government again intervenes. It is essential that Hong Kong honors its duty under the basic law by implementing Article 23 as soon as possible. And all I'd like to say in closing is that as you leave, there's some beautifully signed copies of a book which you care to purchase. Thank you very much.
Thank you very much for that. Really interesting historical look as well. If you don't mind, as the moderator, I take the prerogative of asking the first couple of questions.
Please do.
That gives our guests a chance to think of some questions. Could I just go back in recent history for a moment? You brought up 2019 and the protest, and you brought up the extradition bill. I just want to clarify one thing, because you here called it a legal loophole that was being closed. That's the same term Carrie Lam used, that was a loophole. Various people I talked to said it was not a loophole. China was deliberately not included for extradition from Hong Kong to China because there was not trust in the Chinese legal system. There was not trust because, number one, they have the death penalty, which they don't have here. Number two, they have forced confessions. And so, therefore, it's always referred to as a legal loophole just to get this one guy back from Taiwan. But it was not a loophole that China was not included in extradition for China. Is that correct?
No, I was thinking in a more general sense,
right.
In the sense that, there was a legal loophole perhaps insofar as Taiwan is concerned, for example.
As far as Taiwan's concerned.
Yes. And of course, Macau too.
But mainland China.
Yes, but that's a separate matter, obviously.
Right.
I mean, it could have been included, it need not be included.
Right.
But it so happened that in the bill it was included.
But should it have been included?
But
that's what caused the protests.
That is a matter of political judgment. I mean, I'm not going to enter into that. But there was obviously a legal loophole insofar as this terrible murder case concerned, and everyone wanted the person to be extradited back to Hong Kong.
But LegCo at the time made an offer to pass a one-off bill to send this guy back to Taiwan, and that was refused.
Well, that is a more of a political decision, isn't it, by the people in LegCo. I always make myself very clear. I'm not a politician. I try to speak from a legal point of view. I don't enter any political controversy.
Of course. Yeah, just one other thing about the 2019 protest. I mean, because you mentioned the bomb making and the vandalism and the calls for separatism, which I think everybody here decries. They think it was awful. In the beginning, though, that wasn't the case. There were hundreds of thousands, if not 1 million people out there marching. They weren't calling for separatism. They weren't vandalizing. They were ordinary middle-class Hong Kongers out there. I mean, right now we only hear about the violence and the vandalism by those thugs who went out at the end, but people seem to kind of ignore the fact that you had many people out there who were marching.
I agree with that. But at the end of the day, it's the damage that's done to Hong Kong, the riots and the destructions, of properties and everything. The end results, speak for themselves, isn't it? I mean, I'm sure all of you, many of you know people who have suffered tremendously, businessmen, taxi drivers and all those people, all the livelihood disturbs and everything, economy and everything, So people worry about that. Essentially people are more worried about bread and butter issues, I think.
And since the enactment of the national security law here, we've had student unions disbanding or shut down, the professional teachers union is gone, Civil Human Rights Front is gone, other organizations are gone, books are being pulled off shelves. How does that endanger China's national security?
Well, that's the law that's been passed. Again, I'm not going into that. particular arena. All I'm saying is that, we could have a better, or let's say, we have a better, national security ordinance under Article 23. The present one, to me, is, in a way, it's very cumbersome, onerous, but I think it's been imposed upon us with hardly any input from Hong Kong. But who is to be blamed? We have no choice. I mean, I don't know. I heard that only perhaps a handful of people were involved in drafting this piece of legislation. There's no input from Hong Kong hardly at all. Because legislature never did its job. They prefer to filibuster around and never debate any of these issues. They could have and should have debated properly in Hong Kong. That's my whole point here. Because there's no input from Hong Kong at all. And the proper way is to have it go through the proper channel, proper debate, in Hong Kong, through the legislative system.
But many of the things being done now don't seem to me and others to be national security. They seem to be about internal security, stopping people who have disagreeing opinions, stopping dissent, stopping political parties that have a different point of view. Is that correct?
But that's the law. I mean, the law is there, I mean, or someone's asking me about the law. I said, well, when I was in university, in school, when I first went to London to study, there was I don't know, many of you may have heard of Dicey, the great constitutional lawyer, and he said, if Parliament legislates black is white, then black is white. I mean, you may disagree, but you believe in a democracy, you believe in the supremacy of Parliament, then that's it. I mean, you can be a politician, fight, and change black into black, and don't change black into white. But the great constitutional lawyer said, the supremacy of Parliament demands that. So I'm not here, I'm not a politician. It's a politician's job to change the law. But if the law is there, whether you like it or not, that's how it goes. I mean, I may disagree with the law, but that's the law.
One of the criticisms of the law has been that it's in some ways specific, but in other ways it's very vague. So people don't know where the red lines are. Would you agree with that?
Well, I think that's the matter. I mean, I'm not in a position to say anything about that, because if the law is passed, it's for the judges to interpret the law. I mean, if I'm a politician, I have many views about that. I mean, could as a law, I support the law, but that's a separate matter. But to me, anyway, that once the law is passed, it's for the judges to interpret the law according to the training.
And you think they're doing a good job so far of interpreting it?
Well, so far it seems so good.
Because right now we're saying slogans are now considered a danger to national security. Songs are a danger to national security.
I think that's a matter subject to, I think it's development jurisprudence. I think there'll be lots of cases coming up, maybe subject to interpretation by the judges, based on submission made. I mean, a good judge should be someone who interprets the law according to his own, to the law.
Okay. Let's get some audience questions in here. I have plenty, but I'm sure you have plenty as well. Cliff Buddle.
Mr. Cheng, I've known you many years. I know you care deeply about Hong Kong's legal system. I want to ask you about the impact of the national security law on the way our legal system works, because it seems to me that it allows for the removal of some of the core safeguards that have been built into our system. I mean, we have the chief executive selects the judges. The Secretary for Justice can dispense with a jury trial, even at the High Court. There are restrictions on judicial review, and in exceptional cases, the case can even be taken away from Hong Kong and tried in mainland China. Could you give us your thoughts, please, on the impact that these changes have on Hong Kong's legal system and its reputation around the world?
Thank you very much for your question. But obviously, personally, I would say that these are major inroads made against what we always had in the past. But I think, again, all these things I've said here are in the national security law. I mean, that's the law. May not like it, but I believe that it takes time to see how you have, what damage, if any, or what permanent damage you have made to the Hong Kong system. But I think it's too soon to tell. I mean, there are very few cases, hardly any cases so far, a handful of cases only. Only one High Court trial so far without a jury, I think. The Mr. Tong's case, but again, so you see, it's very early days to tell. But I mean, I agree with you. There's big fundamental inroads into what we understand in the past to be the system. But those are perhaps some of the penalties we have to pay for not having our own Article 23. I mean, the point is that the national security law has been imposed on us. Hardly any input from Hong Kong.
None.
None. A few, I've been told. Perhaps, I suspect, the Secretary of Justice might have an input, but I don't know. But I said very few, if any.
Okay. Question here?
Hello, yeah, thank you very much for your presentation. Getting back to Article 23, I'm just still quite unclear about what added value would be a legislation on Article 23 today. I know you mentioned unaddressed criminal offenses like sedition, treason, theft of state secret, and so on. But being given, and you said it, that national security law is much stronger than what could have been Article 23, I think we can all consider, reading between the lines, and maybe not always between the lines, that all these criminal offenses that you consider unaddressed actually can be addressed under national security law. So could you elaborate a little bit more on why Article 23 legislation is still needed? And my second question would be, you mentioned the need to have proper channels of discussion, that, Article 23 legislation would have been a good opportunity to have some debate locally and everything. How do you think, and how can you consider that this kind of debate and this proper channel, as you call it, can be guaranteed today in Hong Kong, given that the opposition in LegCo is no more?
Well, first part of the question, I think under the current, as I said in my speech, of course, I understand that I spoke very quickly. Under the basic law, Article 23, the number of offences, the present national security law does not cover all the offences spelled out. And the offences yet to be addressed, which must be addressed, there will be treason, sedition, theft of state secret, and a ban on foreign political organization. Those, at least four major type of offences, are not covered under the present national security law. That's the first part of it. But the second part, if I understand correctly, about the what do you call it, the present political situation, and about the what do you call the debate. Obviously, I think it can be done in a very civilized manner. I think so. Perhaps now Hong Kong is more mature, and I don't see why we cannot have rational debate and discussion about.
But she's saying in LegCo there won't be any pan-Democrats, Democratic voices.
More of a matter of choice for them. They decided to resign en bloc. I don't know. Remember that?
Well, a choice is a matter of semantics.
Well, I don't know, but you have to accept the present structure as it is. I mean, I can't change the present structure if there are only more what you call pro-government parties and people there than now, and that's how the system is. I mean.
Question?
Jessica Park.
Please identify yourself too, sir.
Yeah, Jessica Park, member of the FCC.
Thank you.
I think your book needs to be rewritten. I think the whole of what you've said is upside down. You seem to come here and want to blame the Hong Kong people for causing these problems. And I remember back in 1989, Tiananmen Square, and I'm one of those million people walking down the street with a son on my shoulder, and I was delighted. Not for, I mean, I'm patriotic. I'd love for China to be great and to grow and to everyone to be prosper. But what we were hoping for in 1989 was a more democratic China, a more fair China. Yes. And China, what we've seen coming into power through war, and then the mess that it made and the Cultural Revolution and the starvation of all those people. But the positive things, the way that it's blossomed, is great. I'll get on to my question in just a tick. So, and then we've had problems with the Uyghurs, and China hasn't endeared itself to respect of people. People accuse of genocide, whether that's the case or not, I'm not sure. The legal system is terrible, it seems that the common man doesn't have any right in the legal system in China. Even the lawyers who try to defend those people, the lawyers are put into prison. We have the bully boy tactics of the South China Sea. Where can we look to China in these aspects for respect? How can we look up to our leaders? And therefore, if we were able to look up to our leaders, we would remove a lot of these fears of the Article 23. But because we have fear of the leaders of China, we resist. And it's not our fault, it's China's fault and the leadership of China. And so my question to you is, how can we get the CCP to be more benevolent to us and to the people of China itself? Thank you very much.
That's an easy question.
May I thank you first of all for having read my book. I'm very grateful you read my book. And as you say, it needs some revision. Perhaps you might volunteer to do so. But to your question, I don't think I'm in a position here to answer the very wide question at all. I don't think it's a proper question for me to answer. Anyway, thank you very much for your long speech.
Question here? No? One question over here, then I want to look at the veranda, please. I can't see you, so make sure to come to the front. But a question here in the front first. And veranda, just wave if you've got a question.
Hello. My name is Shirley, and I noted that you born in Malaysia and you grew up in Singapore. So I was just wondering, given what happened in Hong Kong during 2019 and 2020, what would have, say, the two iconic leaders, Mahathir's Malaysian, former President Mahathir from Malaysia, or Lee Kuan Yew, President Lee Kuan Yew would have done?
I suppose they would have implemented the provision of the National Internal Security Acts. And I mean, you can detain them for 2 years without trial in Singapore and Malaysia, I believe. So, I mean, Prime Minister Mahathir, might have done so. I don't know, but in Malaysia, it's very, very tough. In Singapore, also a very tough Internal Security Act. They detain you. And of course, they abolished judicial review altogether in Singapore for many, many years. They abolished jury trial when Lee Kuan Yew came into power in the 1960s. So, hardly anyone criticized Singapore very much.
We had a question on the veranda back here. Probably one or two more, one more after that. But let's see how long the question is. And identify yourself first, please.
Sideline. My name is Alok Jain.
Thank you.
My quick question is, one, you mentioned about the legality and the Article 23. Just for the record, Article 23 was withdrawn by the administration. So legally, it's the government who withdrew that piece of legislation. It wasn't withdrawn, or it didn't lead to anything else. It was not forced. Government withdrew it. Number two, how do you define patriotism? And if I take it more bluntly, if as a lawyer, how would you defend yourself as being patriotic?
Well, I mean, of course, bear in mind there's a Patriot Act in the United States. I suppose, generally speaking, I would say a patriot is someone who loves your country. A simple definition, in my opinion.
I guess the question, though, is can you love the country but not love the party?
Of course. It's only logical, isn't it? I mean, of course, it goes without saying.
So people can be critical of the Communist Party but still love China.
Of course. Definitely, 100%. It's only common sense, isn't it? I mean, no government lasts forever.
Okay. One more question here. I think that'll be our last one, then I might have a closing question.
Actually, I'm not asking any question. I'll just tell all people here something I know of. Now, in fact, the National Security Law of China was made only in 2015, and the Constitution Law of China was made in 1982, and was amended 5 times. 1988, 1989, 1999, 2014, and 2019. In fact, this is not new national law. This is the law of national law of China. You know why this is was being introduced to Hong Kong? It's because after 24 years, still Hong Kong cannot make law under Section 23. And in order to save Hong Kong, otherwise Hong Kong will collapse. So the central government of China, the People's Republic of China, the representative there, they decided that Hong Kong must make some law to administer the national law of China to save Hong Kong. And despite of that, Hong Kong will still have to make law under Section 23 of Basic Law. In fact, this time, the making of the national security law is not the level of Hong Kong. It's the level of national of China. So this is no question about any question about any thing about the one country, two system. The system is still running very good, I tell you. This time, the law was made by the central government, but it was only attached to Article 3. And so it does not have to be passed by this Hong Kong law-making body. So this is what I'm telling all people here. Actually, the central government is so good to Hong Kong. And in fact, Hong Kong government has failed to introduce basic law to all of us since 1997. And it's the duty of the Hong Kong government to educate people of Hong Kong, especially the students. And in fact, in the past, those professors and barristers, especially one professor, he claimed that Dr. Sun Yuk-sang had said the words in the Hong Kong University. When he visited Hong Kong University, he said that sometimes violence can be the best solution to a problem. And he put up a banner to show and ask the youngsters to look for him, to help him. And in the election of the committee members of the Hong Kong Law Society last year, he saw a banner, terrible. And I objected to it, and I complained to the authority. And in fact, there was an occasion in the heat of the violence. There was the president of the Secretary for Justice, the president of the Bar Association, also the chair lady with more than 100 lawyers there. I stood up and I said, how come when this barrister said in the public that violence can be the best solution to the problem, and no one corrected him? And now they're considering whether to pardon the youngster. I said, no way. This is terrible. So at last, I want to tell everyone here that with the help of Mr. Cheng Huan, we gave a visit to Mr. Tan Bin Keung, the Secretary for Security, and he agreed with us that we must urge the government of Hong Kong to promote basic law and national security law to the public, in particular to the students.
Okay.
And subsequently, we have this proposal put up, and the law society is very cooperative. And they are working now with this education department, and even Carrie Lam now says in public that she will learn basic law.
Okay.
I think Hong Kong will have good
Thank you very
progress.
much.
Thank you.
you very much for that comment. We got one more question in the back.
My name is Cheng Huan. I'm just an FCC member. So first of all, Cheng Huan, thank you for sharing. I'm told that you are one of Hong Kong's most brilliant and by definition, highest paid barristers. So we appreciate your sharing your views. But my question is this. I think that at some point, maybe in the next 1-2 years, the Article 23 will be passed. And one of the key focus of Hong Kong politics is going to move on. We got to move on. We can't get stuck on this one topic. And I think one of the key focuses in the coming years will be the promise of universal suffrage, promise to the people of Hong Kong under the basic law. Now, I'm very interested in this issue. I really believe that Hong Kong will be a much better place if each person living here is allowed to vote for the chief executive. So in your view, given the brilliance of your legal training, what can we maximize, what can we do to maximize our chances of getting universal suffrage ASAP?
Thank you very much, Chair, for very generous remarks. Well, I think perhaps all of us, or most of us, I think we share your sentiments that obviously I think we should have one person, one vote. I think that's the ultimate aim. And also I think it's also stated in the basic law. But I think how we achieve it and when we achieve it, is said, I think depends very much on how the political situation improves in the next few years. But unfortunately, we missed the opportunity a few years ago to have that limited suffrage. There was a missed opportunity, and I think it will take, not in the foreseeable future, I think it will take quite some time, I'm sorry to say, but I think after the enactment of Article 23, as soon as possible, I think the chances will improve that we would have universal suffrage. But I think only after Article 23 is passed. Some of the red lines are there, and China would never allow, universal suffrage under the present system, so to say. Bear in mind the lessons they've learned in the past.
Okay, and one last question from me, if you will, if you put on your hat as a former journalist. Does Hong Kong need a fake news law?
I think every country needs a new fake law, wouldn't you?
I'm asking you.
I say every country needs one. Who's in favor of fake laws? Fake news.
Fake news.
Fake news. Who's in favor of fake news? I don't see anyone. It's awful things, for example, if a newspaper would say something very, very nasty about you, absolutely completely fake, you would not like it, would you?
Well, there are existing criminal libel laws.
They're very difficult to implement. And you must be very, very rich to be able to do so. I wouldn't recommend anyone to go down the road, the defamation road. You may end up in the quarter-final appeal. It'll take about 5 years. I always remember someone told me in my younger days that, if you read something on page 3 that offends you personally, turn to page 4. By then, you've forgotten about it. But if you stick on to page 3, you might remember for the next 5 years. You go down defamation route.
I think the old saying was, as long as they spell your name right.
Thank you very much.
Thank you, Mr. Cheng. We brought you into the eye of the typhoon at the FCC, but I think you'll see the skies are clear.
And thank you very much all for coming.
And
thank you very much.
And here's a small gift for us. Oh. Unfortunately, there's no umbrella in here, so I hope you brought one of your own to get home. But we will give you this. Thank you very much.
Thank you very much.
Big warm applause. Thank you.